Hello, people. Hello. Let me make sure my mic is on the right mic because sometimes these things don't work. All right, so we are good. Mic is good. Audio's good. Yes, Nervy, I am late. I'm 5 minutes late. It's called CP time, but I don't think you can say that anymore. Hold on, let me turn off this audio so I stop hearing myself. All right. How's everybody doing tonight? How many people we got here watching this thing? Damn, 118 people. All right. I gotta do good by you guys. All right, close this. I'm hearing myself like 3 times here. All right. Are we on? Yes. All right. Sorry, yes, 120. Nate the Great. What's going on? What's going on? I was trying to resolve some technical issues it looked like I was having, but here is watching you daily. Watching you daily. What are you saying? You are saying Nate the lawyer, the court is holding you in contempt for your fined $1,000. Uh-oh. That's the nightmare. That's the nightmare, Daily. That is the nightmare. Oh my God. Here we go. Always 5 minutes late. People should be used to it. Damn, Secrets Girl. You're right. I am always 5 minutes late. That is a shame. I am going to do better, people. I am going to do better. All right. So let's go over Steve's recent filing. I'm looking at this thing, and it is looking interesting. My first impressions of it when I first read it was like, oh my God, this woman just went for like the jugular. She's just like going for its body right now. This was a good response. This was a good response. We're going to go through this, but Kyle hired a good attorney. The money that was given to Kyle went to good use. Super sticker. Thanks, Leroy, for the super sticker. Yeah, this was good. This was good. It's funny because it's usually I like to build it up. I like to talk about it, but I just think you just need to read it, and you guys just need to hear it just to hear for yourself how this woman just like destroyed Steve's whole argument. She just like went in on it. Now, for those of you who are new here, let me take this a bit of water. For those of you who are new here, this is a case that we've been following. I got like maybe 4,000 fans in the past like 2 weeks, so I gotta let people know what's up. There was a show on YouTube called the Non Sequitur Show. It's a great show, right? I've even been on the show, so it was a really good show. And it had two hosts, Kyle Kurtz and Steve McRae. So they made it up to like 30,000 subs. Kyle wanted to go a new direction without Steve and kick Steve off the show, but also taking all the money and funds and all this other stuff. So Kyle bounced, kicked Steve out. Steve then went rogue and more or less destroyed the show and everything, and then sued Kyle in court. Kyle didn't show up to the lawsuit. Steve got a default judgment, and we were able to follow the case from when they were threatening the lawsuit all the way through to this point now, where Steve looked like he had won. He did a live stream. He did a stream, right? I've won. But Kyle then comes back and tells the court that he wasn't served properly. Process service. Very simple thing. So now we're waiting for the judge to rule about process service. So Kyle eventually got an attorney. The attorney made their argument for process service. Steve's attorneys responded saying more or less that the fact that Kyle actually got the papers, right, he was served properly. So they were saying that they have the presumption and that it doesn't matter where the papers were sent. I even asked Ruhef. I had Ruhef on the channel. I don't know if you guys saw that, but when Ruhef came to the channel, Ruhef said that they could have sent it to a pit, but as soon as somebody in that pit signs for it, and if Kyle would have eventually got the papers, then he would have been served properly. Now, I don't know how it is in North Carolina because I don't practice in North Carolina. I practice here in New York. But if that's the way it goes in North Carolina, it seems to me would have defeated what service is about. Service is about making sure the defendant is notified of the lawsuit. So that was the argument that we were kind of left with. So Steve's lawyer more or less just was saying that Kyle's mom was his agent. They could send it to a pit. They had the presumption. And that's kind of where we left off. Now, I will say this. I think Steve's lawyer did a good job for two reasons. The first thing was he took a whole bunch of shit and turned it into lemonade, right? Because Steve had been making all these admissions that he served, he sent it to the wrong address and all that stuff. So the lawyer did what he could, what he had. He had garbage, and he's tried to make it turn into gold. I think he accomplished that, right? He accomplished that. But now I think in this response, you'll see that you can only take these arguments so far before you get smacked back. And we'll see the smack back. So let me read these 2 super chats. Damn, Nate, I've been waiting for this stream. Ha ha ha. You are killing it. What is that? Ruffles? Thanks, Nervy. And then, you said a $10 one. What's going on here? Oh, it's going fast here. Oops. Here we go. Had court today. My adoption of my daughter went through. Oh, congratulations. Celebratory super chat plus obligations and block fee. Oh, the obligatory ad block fee. Thank you, Nervy. Congratulations. That's awesome, man. I can just imagine how that feels. Congratulations, bro. The court system does good things sometimes, so I'm happy to hear that, brother. So now that for people who are new, now that they have the backstory, we gotta get into it. So let's see how Kyle's attorney gave Steve's lawyer a little spanking here. I think in each way. If you're gonna now, because I'm going to switch screens and be on the because I'm doing this, and when you switch screens, you can tag me in the chat if you want me to answer a question. I'm going to try to hold questions to the end. Super chats, I'll try to be a little bit more responsive to, but that's because they pop up so easily and I can see them. And the other, if you just tag me for some reason, StreamYard, it's hard to pop up. So, hey Nate, my chocolate chip muffin of sunrise and happiness. Make sure to give your current over and under on the outcome of the case. I will, Timmy. I will. And I think it has changed. Before this stream, I was 60-40. But that has changed after reading this document. Thank you for the side-up follow, Super Set Jimmy. So let's just get into it. Let me stop suspending. I've been cooking it. Now it's time to feed you people the main course. So here we go. Kyle Curtis, his response by his lawyer, who goes through. So she first starts off, pursuant to Rule 77 of the North Carolina Business Court Rules, defendant Kyle Curtis submits this reply brief. So that's all she's saying. What this is about. I'm replying to Steve's attorney's last thing. Introduction. Mr. McCray, response confirms the key point of Mr. Curtis's amended motion to set aside. Now, I think she's starting off with the bomb right there, right? Boom. Like, as soon as we start off right now, we're good. Steve's attorney confirmed the key point of the argument. So it seems like, she's laying the groundwork right now, right? Hey, his response actually helped my argument. So now she's going to have to go through that. So here it is, that Mr. Curtis had not been properly served with the summons and complaint of the lawsuit. So that's her conclusion. Hey, McCray's response confirms this key point that Kyle wasn't served properly. Boom. First, Mr. McCray does not seriously contest Mr. Curtis was not served at a proper address under Rule 4, such as Mr. Curtis's dwelling or usual place of abode. Rather, he argues that the address at which Mr. Curtis was served is irrelevant. Remember, that's what Ruhef said even in our stream. He said it's irrelevant. You can send it to a pit. Because Mr. Curtis's mother was authorized to accept service on her son's behalf. The affidavit accompanying this brief makes it clear that Mr. Curtis's mom is not and never was an agent authorized to accept service on Mr. Curtis's behalf. Moreover, the complaint served on Mr. Curtis's mother was not delivered to Mr. Curtis as required by Rule 4. Second, Mr. McCray tries to sidestep proper service by arguing Mr. Curtis received actual notice of the complaint. Actual notice of a lawsuit, however, does not remedy defective service. As shown below, and in Mr. Curtis's opening brief, Mr. Curtis has rebutted the presumption of proper service. As a result, the partial default judgment entered against him is void and must be set aside. So that's how you started off. She's just starting off with the pure bombs. This is all BS. He's got it all wrong, and we're going to go through it line by line, right? So she's just hitting him. She starting right off hitting him with the bombs. Matter of fact, his response was good because it helped us. And I'm going to explain that in this suit. Now I'm going to take a break for any questions since we got through the first part before we get to the legal arguments. So I think this is clear and I think it's concise. And I actually wrote out the four things that we can expect to see later in the document. The first thing we're going to expect to see is that she says that first, McCrae doesn't seriously contest that it was given to Mr. Curtis at the proper address, right? Even McCrae himself says it was sent to an old address. So that's not even as contested. It went to a wrong address. Second, she's going to attack the agent mother theory, right? The mother was Kyle's agent. She says that she was never, will never be his agent. She's going to show why that is also true. She's also going to show something new, which is it was never delivered to Kyle Curtis. Now, we got to understand where she's going with that because that's what she's saying. It wasn't delivered to Kyle Curtis. So that's something new that we have. And she said she's going to say something about that here. And then last but not least, she's going to show how actual notice does not give you proper service. And that's what Ruhef was essentially arguing. If you actually got the papers, you were served properly. And one of his arguments on Twitter the other day was that can you find a case where the person actually got the papers and the court found they were not served properly. So that's his argument. If you get the papers, you were served properly. So those are the four things she's going to hit. Now, again, does anybody have any questions before I go on? I'm doing a quick scan to the chat. No. 3, 2, 1. Hold your peace because I'm going back in. All right. Argument. Mr. Curtis has rebutted the presumption of service that service was proper. In his opening brief, Mr. Curtis showed that the partial default judgment entered against him is void under Rule 60b-4 because Mr. Curtis was not served with the summons and complaint. Specifically, Mr. McCrae attempted to serve Mr. Curtis by certified mail to an old address. Now, obviously, that's not even in contention, right? They agree it was an old address. He didn't live there. In response, Mr. McCrae does not dispute that the complaint was mailed to an old address. Again, video, he didn't even say that in his return brief. They even admitted that he only lived there likely till July 15th. So he wasn't living at this place. Instead, Mr. McCrae argues that Kyle Curtis's mother is an agent authorized to accept service on Mr. Curtis's behalf, and that Mr. Curtis had actual notice of the lawsuit. Those were the two big main points of Steve's actual brief, that Kyle Curtis was his mother and that he had actual notice of the lawsuit. As shown below in the affidavit accompanying this brief, Mr. Curtis's mom is not and never was an agent authorized to accept service on her son's behalf. Moreover, actual notice does not cure improper service. Now, here I'll say it's time to be fair. This last line, you got to put a citation here, right? You got to give me a court citation where you put moreover, actual notice does not cure improper service. There are many cases that cite that. Granville cites that. You put that in there and you knock it out. You know what I'm saying? You don't put that in without the citation because it just gives it credit, gives your source credibility. So that's the first place why I hit, even though this is correct, but I would rather you like to have a citation for this. You know what I mean? Let me see if I missed any super chats or anything. Nope. I got this one right. Yep. All right. Thanks again, Timmy S, for the super chat. I appreciate it, brother. All right. Moving on. So now we're moving into her first legal argument. Mr. Curtis's mother is not an agent authorized to accept service on Mr. Curtis's behalf. Remember, when I spoke to Ruhef, his argument, one of his main arguments was this agent argument. So she's attacking that argument first. In his response, Mr. McCrae argues that even if Mr. Curtis did not live with his mother on August 30th, 2019, service was proper because Mr. Curtis's mother was authorized to accept service on his behalf. This argument misses the point. Actually, this argument misses the mark. Now, she cites Osman v. Reese. Now, two things about Osman. Osman is an unpublished case. That generally means it's not good to use as precedent for lower courts, right? The appeals court, I think sometimes up to like 90% of some appeals court cases are unpublished. Now, the reason why they're unpublished is because they really don't add anything to the lineage of the precedent. It's just like it's so obvious that we don't really need to have this out there as controlling precedent over these type of cases when you have cases that are more point or stand for a more general rule than this particular case. So Osman generally is a case that you would not cite. But I think here the parallels are close enough where you're citing it to show, well, here's how the court thought about it in this case, but yet that's not controlling, obviously, in this particular case. But this is how the appeals court thought about it with facts that are pretty similar. So that's one thing that you have to realize about Osman. That is a technical flaw in this argument, is that you're using an unpublished case. Let me know, scan in the chat to see if there's any questions for me. All right. I think I'm good. All right. So again, any questions in the chat? I'll be scanning it back and forth. So now we go to this unpublished opinion, Osman v. Reese. Now, Osman v. Reese is instructive on this point, she writes. In Osman, the plaintiff served the defendant with a summons and complaint by certified mail at his place of business. Now, this is two distinctions here. Number one, this didn't just go to some random address. This went to his place of business, and he was served by certified mail. So you have two things that are pretty much in common, except in Kyle's case, it was served at some old address. But here they served it at the defendant's place of business, which is good enough generally. So a coworker signed for the certified mail slip for the defendant, and the defendant received notice of the complaint, but never received a copy of the complaint from his coworker. So here, and I think this is where Ruhef's argument comes into play. Ruhef is saying, well, even in this case, the defendant never got the summons and complaint. That's the reason why it was overturned. So that's what I think she's trying to clear up. Is that the real reason? So here it says the defendant received notice of the complaint, but never received a copy of the complaint from a coworker. Now, to rebut the presumption of service, which she's trying to do here, the defendant submitted an affidavit stating that his coworker was not his agent and that the summons and complaint were never delivered to him. The trial court dismissed the plaintiff's complaint for insufficient service of process, and the plaintiff appealed. So she's saying here that soon as the defendant in this case gave an affidavit saying this guy was not my agent, then that was enough to destroy the presumption, right? You presume that this was his agent. He's now destroyed it by saying, hey, this guy was not my agent. But again, you got to be fair. When you're dealing with these type of cases, you got to be fair to both sides. In that case, there were two affidavits. There was the affidavit of the defendant in Osman. There was the affidavit of the defendant, and there was the affidavit of the mother. I'm saying the mother. There was an affidavit of the defendant and an affidavit of the person who was not the agent. They both turned an affidavit saying. So I don't know if I didn't see that here, but in Osman, you did have two affidavits. You had the affidavit of the defendant and the guy who signed for it. They both said that he wasn't an agent. So she's saying that you only need one, but in the case, they had two. I'm just trying to be fair. That's what Osman says. So in Osman, we read this where the trial court dismissed it. So let me put it back so you guys can see it. All right, so we are here. Sorry, I scrolled down too much. Okay, insufficient process, the plaintiff appealed. Okay, so here we go. So but they're still talking about an Osman. The appeals court affirmed the trial court's conclusion that service was insufficient. This was for Osman. The court held that Rule 4, service by certified mail, is achieved by mailing a copy of the summons and complaint. And this is the part that she's highlighted. Addressed to the party to be served, which it was, and, quote, delivered to the addressee. And she quotes both the statute about saying this delivered to the addressee. Now, here's her, I think, her coup d'etat. Although the plaintiff produced evidence through an affidavit of service with return receipt that the summons and complaint were delivered to the defendant's place of business, this is for Osman, addressed to the defendant successfully rebutted the presumption with two affidavits. As I was saying before, it was 2 affidavits, the guy who wasn't the agent. So she's saying the presumption was rebutted with just 2 affidavits. And I think she has those affidavits with this. So this really, I think, attacks Steve's argument and Rueff's argument that they have this presumption. Because here it says the only thing you need is those affidavits saying that she wasn't an agent to overcome that presumption. So the presumption of service, that's what she's attacking now. You don't have the presumption because I have 2 affidavits saying that she was not an agent, or I have an affidavit saying that she was not an agent, and that affidavit is attached. So here she then goes on to say, here, like in Osman, Mr. McRae attempted to serve Mr. Curtis by certified mail. True. And the certified mail slip was signed by someone who is not an agent, authorized by appointment or law to be served or to accept service of process. Again, if we're accepting this argument, we'd say true. Moreover, like in Osman, a copy of the complaint was not delivered to Mr. Curtis, in this case, until several months after attempted delivery by certified mail. So here, this seems to be a balance. At one point, she's saying that she didn't get that Kyle didn't got the papers, but he didn't get them to several months after this happened. So here they even take they're coaching that argument to say, hey, at least he got the papers, but it was months later. You know, it wasn't in time where he could have actually responded or did anything, because when you're served with process, you only have, I think, 30 days to respond to the lawsuit. So if you don't get the papers till 7 months down the road, then essentially you couldn't respond, right? Because it's essentially like you didn't get the papers. So that's what they're saying. So I think they're hedging their bets on the fact that, hey, he did get the papers, but he didn't get them in time. Oh, thanks for the super chat. Hey, thanks, Donna. Thanks for the super chat. It's $5. Flying Monkey. All right. Check Agrippa's comment in the chat. Agrippa. Let me see. Check Agrippa's comment in the chat. Thank you, Flying Monkey. Agrippa says he's a boomer. Okay. I checked Agrippa's comment. Not well, but I'm in touch. I don't know. Okay. Oh, here we go. Nate the lawyer. Peter Riley, before journalists, has reviewed the finances, agrees with the position in general. Check the Discord, Twitter. Steve's not happy. Boom. That's crazy. I got to check that out. You see, you messed up the flow, though. Now I want to talk. Now I want to look at the finances. But I will. And thank you for the super chat. Thank you for the super chat, Flying Monkey. Thank you for the super chat. Who else was that? Donna McDaniels. Thank you for the super chat. $20 from CJ. Thank you. Great job, Nate. Kyle's lawyer will be proud. Thank you. You know, she's killing it here. So let me get back to the paperwork. So obviously, this lawyer is going through Steve's response and surgically just destroying every argument, right? Destroying every argument. And she's found this case that she's saying, hey, you know, this case destroys these arguments. You know, I don't even have to argue against it. And the fact of the matter is, they agree that the thing did not go to his house. So this is interesting. This is interesting. Let me go back so you guys can see. Oh, how long is this going on? I don't know. Hopefully another 30 minutes, but we'll see. Here we go. Let me go back to this document. Okay. So whatsoever, like in Osmond, a copy of the plate was not delivered, but he said he got it several months later. Indeed, here, Mr. Curtis's argument for overcoming the presumption of proper service is even stronger than Osmond, because unlike the defendant in Osmond, Mr. Curtis was not even served at a proper address. So he's saying that, hey, Kyle is in a better position than Osmond because Osmond got it at his place of business, right? Such as his place of business, dwelling house, or usual place of abode. And she has this footnote here. Let me read these footnotes because these footnotes I think were good. All right, so her footnote 1 was Kyle Curtis submits the affidavit in reply to Steve McRae's affidavit. So blah, 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 and she gives legal citations on why she could actually make this reply. So here it is. And it says right here, allowing a reply to the affidavit to address points raised in a non-movement response brief. So she's arguing at the point that she can actually respond to this. And here's the law. This is number 2, which we just read. In his response, Mr. McCrae alludes to the fact that a defendant can have multiple dwellings at which he or she can be served. And that's true. And he did allude to that. While that may be true, there is no evidence, because they didn't provide anything, that Mr. Curtis has multiple dwelling homes or place of abodes at which service would be proper under Rule 4. And there has been no such allegation that Mr. Curtis was served at his place of business. They never alleged it, so it's like it never happened. So that's why it's good to read the footnotes, because she's saying that, hey, they never even said that this was his place of business. They can't just now make it up, just throw it in there at last minute, right? So this is what we have to now go with. You know, you can't just they can allude to it, but they haven't said it. So he wasn't served at a business. They were saying that he was served at his house, and obviously we all know that wasn't his house. In sum, Mr. Curtis has overcome the presumption of proper service by showing that he was served at an old address. 2, certified mail slip was signed by someone who was not Mr. Curtis's authorized agent. And 3, the complaint was not delivered to Mr. Curtis. Boom, boom, boom. Service was improper. This is what we're talking about. Boom. Laura says, didn't Kyle say he has never been served at all? No, well, he's not saying he was served. He's saying he got the papers, but they're saying he got the papers 7 months later. So, you know, that's what he's saying. He's saying that they sent it to his mom, but he didn't get the papers till a ways later. So it wouldn't matter. Get real, Nate. No, I meant how long can this case go back and forth? I think we're pretty much at the end, because this service issue, if this service issue goes for Kyle, then we got a lot to go, right? Because we got a whole trial to go through now. You know, this is literally the first step. If Kyle wins, we're back at step 1. If Kyle wins, we're back at step 1. Crazy, right? So yeah, so this took a year just to get to this point. So just imagine how long it's going to take to the next point, because now you got a trial. Now you get, you got a lot going on. But Nate, you haven't seen Steve's secret evidence yet. That is true. Ruhef and I believe Ruhef a little bit when he says he has the secret evidence, right? Because I don't think Ruhef is the type of guy who will throw the secret evidence card out and not have something. Steve, yes. Steve still has secret evidence that Warden is a good guy, right? He still has secret evidence that he's innocent, serial rapist. So I just don't know. Nate the lawyer, I would have used this one service was conducted at the prior address instead of what the lawyer wrote. I think that's what they're trying to get over, because let's not forget, you can't. Service is something where it's about notifying the defendant that he's being sued, and giving him an opportunity to go and fight the lawsuit. So that's why usually serving old addresses and stuff are no good. And I think Steve's lawyer realized that, and that's why the fight was like, okay, well, maybe we can serve his agent, because if he's just like these Hollywood actors and these prominent business people, you can't find them to serve them, right? But they have agents, and you can serve their agents, just like with corporations. So I think they understood the flaws in their case, like all lawyers do. You honestly assess and you say, well, this housing issue is a problem, right? We didn't give it to him as an address issue, and you try to make an argument around it. And I think this lawyer I think Steve's lawyer is exposing that fact. Thanks for the super chat. Thanks for the question, but thanks for the super chat, Angry Roach. Let me go back to the document, because I don't want to bore people to death here. All right, so she's given 3 reasons why the presumption of service should be overcome. Number 1, served at an old address. Number 2, certified mail slip was signed by somebody other than was signed by someone who was not Kyle's agent. And 3, that it wasn't delivered to Kyle. So she knocks down each one of those. Boom, 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 boom. Right, done. We're over with those. So now she goes on to the next argument that they use. Notice is insufficient to overcome defective service, because that was one of the cores in both Steve and Ruhef's argument is that actual notice of the lawsuit was enough. He knew. Remember, they had the clip. The papers that I was served, the paper that I was served. They were saying that since he knew he was served properly. So let's see how she responds to that piece of it. In his opening brief, Mr. Curtis showed that actual notice of the lawsuit is insufficient to overcome defective service. Mr. McCray relies on Granville v. Tipton and Fender. Now, remember when I reviewed them, I noticed that too. They relied on these two cases, and Osmond showed how it was bad to rely on these cases for actual notice. And she puts here to try to sidestep this principle that reliance is misplaced. Now, if you notice, she also all of her opening sentences kind of ends with this. Here's their argument, but here's why it's misplaced. Here's why they're wrong. Now she goes into it. In Granville and Fender, the Court of Appeals considered actual notice only in determining that a presumption of proper service had been established. See Granville v. Tipton and see Fender. Osmond is instructive on the role that actual notice plays in determining sufficiency of service. There, the plaintiff tried to overcome defective service by arguing that the defendant had actual notice of the lawsuit and therefore could not rebut the presumption of service. That was one of the arguments in Osmond. And she puts the cite here. In fact, the plaintiff cited Granville and Fender, just like Steve McCray does in his response. And remember when I did my last stream, I said, look, that's exactly what he's doing. He's citing Granville and Fender the same way they're doing in Osmond. And she noticed it too. So she's putting it right here. Yes, he actually even used the same two cases. So what does she say? The Court of Appeals distilled Granville and Fender as follows. So she's saying here, I'm just going to take the quote from the case and it speaks for itself. And then she starts with the quotation marks here. So let's read it. Let's see the quote. She just say, here's the quote. You read it, court, and you decide what it means. Neither Granville nor Fender stands for the proposition as long as the defendant had actual notice and proper service on the defendant would vest the trial court with personal jurisdiction. Osmond. Indeed, while defective service of process may give the defending party sufficient and actual notice of the proceedings, that's what Steve and them are arguing, such actual notice does not give the court jurisdiction over the party. And then they cite a case within Osmond. Then she ends, in sum, even if Mr. Curtis had actual notice of the lawsuit, that notice is insufficient to confer jurisdiction over Mr. Curtis. See Granville, see Fender, see Osmond, see Thomas. That is how you lay it out. Boom. Nate the lawyer. Wonder if Ruhef's secret evidence had something to do with the service case. He argued with Batty. Maybe. I saw them arguing on Twitter, but I really didn't get into it because I've been having a long week. But maybe. See if anybody had any questions for me. So this is so we're. Oh, has Nate muted? Did I mute? No, I didn't mute. Oh, this guy scared me. I'm like, has Nate muted? Boom. Nah, I haven't muted. I can still be heard, thank God. So, yeah. So she literally blew up the actual notice argument. So she's saying actual notice doesn't matter. All this other stuff doesn't matter. And Osmond speaks to it. So again, point by point destruction of Steve's case. Point by point by point. Let's go back into the end. She at the end says, Mr. McCray's objection and motion to strike should be disregarded. Now, this is something interesting. Let me put the camera on me for a second. This is something interesting. In Steve's last filing, it first started off with a paragraph that said, the court's rules don't allow amended motions, which is kind of crazy because usually most courts allow amended motions. But so he was saying, the court rules don't say that you can amend motions, so you shouldn't be able to. And, maybe like a paragraph and a half of it. And just saying that Kyle shouldn't be allowed to either amend a motion or put in further responses to this. So that, and it was like kind of a throwaway little thing, but it started early. So she's responding to that. And this is what she says. In his response, Mr. McCray also argues that Mr. Curtis's amended motion, put this up, that Mr. Curtis's amended motion to set aside the entry for default judgment is procedurally improper on the grounds that the business court rules do not contemplate amended motions. He's saying that it's not even in there, right? And again, she ends that first sentence with this argument is misplaced. The fact that the business court rules do not reference amended motions does not mean that amended motions are not allowed. To the contrary, there is no rule in the business court, nor federal, nor North Carolina rules of civil procedure that prevents a party from amending her motion before the motion has been ruled on. Here are all the case citations. So she lays out a whole bunch of case citations, right? And here she even quotes one. Overruling arguments about the alleged now I can't say this word now because I've been trying to think about it. Of the amended motion to dismiss and electing to consider the amended motion in the interest of justice. Now I'm going to be stuck with can't saying this word all night. I don't know why I've got a brain fart. So essentially, what's happening is that she's saying, yes, here's even a case where somebody kind of argued that, and you can still, file amended motions. And just because the rules don't say you can do it, doesn't mean you can't do it. And, she goes through all the rules. There's no rule that says you can't amend a motion. Matter of fact, here's a case where they did amend a motion. So in any event, she says, just to get away from that, in any event, business courts rule do address the form in which motions must be presented. So the motion that Steve's lawyer made, she's saying that there's a way that you have to do it. And I think she's going to go into right now how Steve's lawyer messed up. Business Court Rule 7.2. This was a problem with Steve's lawyer's response. He didn't cite any rule, but he was saying that there was no rule, so that's why he can cite no rule. But here she goes right into the rules. Business Court Rule 7.2 makes it clear that all motions must be accompanied by a brief and must be set out in a separate document. Now, Steve's last response did two things, right? It responded to her initial her amended motion to set aside the default judgment. But what he was supposed to do, if he was going to make the motion to strike, he's supposed to make that in a separate document. So he couldn't add it together with that first document. So that response to her first filing, you couldn't put them both in that same document because by rule, it has to be in a separate document. So the fact that he put it in his response violated the rules. So what did she say? Mr. McCray's attempt to include a motion to strike in his response to Mr. Curtis's motion to set aside violates Rule 7.2, and it should be summarily denied. So she's saying that this should be denied not only because it's allowed, but because he didn't even do it the right way, right? And here's the rules. He's sitting there saying that this rule doesn't exist, but doesn't even follow the rules that are there. That's what she's saying. Now, this is just a slap in the face. This is just showing that this guy's just reaching for the stars, right? Because he's saying that, we should make up rules, right? That you can't amend motions because they're not there. But then he's not even following the rules that are actually there. Makes you look a little silly. So here we go. And then she cites the case, ID, stating that the court may summarily deny a motion that is unaccompanied by a brief. And that's what happened here. It's a motion that was unaccompanied by a brief. Conclusion. Let me go back to the chat to see if I have any questions because I've been monologuing for a couple of seconds. All right, nothing. I can only scan real quick, so I'm sorry if I miss anybody. I'm sorry. So, conclusion. As Mr. Curtis noted in his opening brief, the provisions for setting aside a default judgment are to be liberally construed so as to give a litigant an opportunity to have the case disposed of the merits. See citation. Thus, any doubt should be resolved in favor of setting aside an entry for default. So, in this conclusion, she goes right back to the core principle. If there's any confusion, if this is a tie goes to the runner. Kyle is the runner. Tie goes to the runner. Kyle is running. He gets the tie. That's what she's saying. That's what her conclusion starts with. If you're confused, if you have a doubt, if it's 50-50, you got to give it to Kyle. Again, giving it just that extra little boost just to say, you know, we have more on our side. You know, this is unfair. The courts disfavor default judgments. This is a very good argument to end with because it's very powerful. If the judge has any, unless it's conclusive, favoring to overturning it and letting him have his day in court. Very good stuff. Very good stuff. And at the end of the day, she says, for the reasons above, for the reasons stated in this brief and in Mr. Curtis's opening brief, defendant Kyle Russell Curtis respectfully moves this court to set aside the entry for default judgment under North Carolina Rules of Civil Procedure 55B and to set aside the partial default judgment under North Carolina Rules of Civil Procedure 60B and to grant all other relief deemed necessary. This is today, Scotty Forbes Lee. Case closed. Boom. So what do you guys think? I think she crushed it. I think she crushed it. This was good work. For those of you who donated the Kyle's legal fee, she came through for you. She came through for poor Kyle. You know, someone asked me early in the stream, what did this change my equation? I was at 60-40. This made me like 80-20. This made me like 80-20 because I really don't see how can you send it to somebody's old address? You know, it was written better. It was more concise. It hit all the points. Like, I don't see what Steve's argument is. She destroyed it. She destroyed this. She destroyed their whole brief. Yeah, Lisa. She destroyed their whole brief. It's crazy. Secret Squirrel, I think Scotty is my second favorite lawyer. Oh, thank you for the 5 pounds. Thank you, Secret Squirrel. Thank you for the 5 pounds. Yeah, she killed her. She killed it. I don't know. Because Steve and them, that's all they have. You could send it to the wrong address, right? You could send it to his last known address. It's 100 years ago. Last known address. I found some golden plates. I was going to start a religion with them when I found them in upstate New York. Should I send them to Steve as secret evidence? Yes. Yes, you should. I don't know what secret evidence. They still on the secret evidence thing. I don't know what the secret evidence thing comes from. Leroy, I have a question, Nate. Who is this McCrae person? And yeah, she crushed it. Yeah, I don't know. I think this made me even. Now I'll speak to Ruef again because Ruef usually, you know, he brings up some good points, but she seems to me to just put the real, like, this is talking bullshit. Even a little. The thing I do appreciate about this is even a little thing at the end, right? Even a little smack at the end, like, you know, even your little pathetic attempt to get this thing, you know, thrown out, right? To stop me from filing this was itself defective, you know? Was itself, you know, you can't. And think about this: the arguments that she has is that they never sent anything to Kyle's proper address, right? Even when he replied and gave him the proper address, they were still sending it to the wrong address, right? So he's never got anything. This has never been fair for Kyle. That's their argument. You know, they said Kyle got the documents. Yeah, he got them 10 months later. I don't know. I would not bet on this. I know Steve is saying Steve is putting out $1,000 for you know, he's betting people $1,000 that he's going to win, that he knows he's going to win. So if you got $1,000, you know, he might be giving away free money. I don't know if he's going to pay up, but it seems like he's giving away free money because this was crazy. Nikida, what is it? Nikida. Am I saying it right? The two. Well, the keyed manhole says Steve has burial secret evidence. She has no chance. Yeah, I don't know what the secret evidence is. Unless the secret evidence is the picture of him actually getting the damn notice from the post office. You know, I'm talking about, even think about the whole thing is messed up, right? They said in the papers that a sheriff was the one that mailed it, but it wasn't the sheriff, it was a lawyer. It's just like, it's always got so many different issues that you just don't, I just don't know how the judges is going to overcome this. It's just, I don't understand how people can say you can just send stuff to someone's old address. It just doesn't work. That is not how you do service of process. It would change all the rules. I can send it to someone's old address. I don't know. I just don't know. Here we go. If it's overturned, can Kyle use new figures for the new show? Steve is on as evidence to support Kyle's fee is reasonable. Wife gone wild. Yes, 110%. And that's what I would do. If we go on a trial and try to see if these fees are reasonable, that would be it. Well, hold on. You got to show for $3,000 now. Not only are these reasonable, I'm being undercharged. I should be charging more, but I was sacrificing for the partnership, or I was sacrificing for the business. I suspect that would be Kyle's argument. But one thing I'm going to ask you guys before I get out of here, I want to ask you guys, if Kyle, because Kyle's going to need some more money, right? Let's say if this goes to past the hearing, would you guys be willing to give up some more money so Kyle can keep this attorney? Because she's not going to be working for free, right? That $5,000 is pretty much done. She's got these 2 filings in, she's got to do the court hearing, and that's going to be it, right? So do you think Kyle can raise another $5,000 to keep this lawyer on? Oh wow, a lot of people are saying yes. That's what he's going to need to do. I think if he wins, I think more people will be happy to keep him on, but if he loses, I think he might be out of luck. Well, he's going to need damn. See, all these people willing to keep this bullshit case on for another year, and I can't get a channel membership out of half you people. Maybe I gotta beat up Steve a little bit more. Nate the lawyer, where do I send my invoices? oh yeah. No, hey, it's the gift that keeps on giving. For $5 or $10, right? You give to the lawsuit, and you get a year's worth of happiness from it. Oh, I'm sorry, poor Light. Oh, check out Light. It's funny because I got that. I don't know if you guys got those heard of those new special light bulbs. They're not really new. They've been around the LED light bulbs, not the LED, the Wi-Fi light bulbs. So Lamp, I gave Lamp an upgrade. Let me see if I can. I feel like an old person now using technology. Here we go. You see, Lamp is like changing. You can't see the color change on Lamp, but whatever. I can turn it off and turn it on now. So Lamp is moving up. Lamp Killer, yes. Oh, we got a new member. Hey, new member. This is Mini Vitz. Hey, what's going on? Thanks for joining. Thanks for joining the team. I appreciate it. Thanks again, Lamp Killer. Thank you. Thanks for the 5 pound secrets, girl, Lamp Killer. All right, so I'm about to get out of here. Here is Gene. Take care of the lamp. Oh yeah, this is my baby. So I'm going to get out of here, but I really want to know, what do you guys think? Now that you've gotten Kyle's side, now that you've gotten Steve's side, where are you at? Are you with me? I'm at 80-20 Kyle, but it's up to the judge. You got to tell me where you're at. Leave it in the comment section. Just put 50-50, 20-40. I would like to gauge where people are at right now, because for me, I would actually be 100%, but I'm just giving the 20% I'm actually giving is because I just don't know North Carolina law. Like, I don't know, there could be some procedural something I'm missing. There's something, but I'm at I'm really at 80-90%. Now, I've been in situations where I thought it was guaranteed to win and things just didn't work out. So, I understand the law is fickle like that, but I'm really, if I was Steve and them, I'd be really concerned. This wouldn't be like something I'd be like, oh my God, we got this. I'd be like, oh my, we could have some problems here. So again, Let me know. Definitely just throw some numbers down. I just really want to see if am I just crazy? Because I'm at this point, I'm thinking I'm just like insane. Am I just crazy and then not seeing it? What am I missing here? I had Ruef on. He explained it to me, but it didn't convince me. It brought me down to 60-40. But now with this response, I don't see. You didn't see it. We went to the wrong address. It is what it is. Thank you, Tammy. Tammy, thank you for becoming a member. We got a new member, Tammy. Everybody, welcome Tammy to the party. All right, people. Listen, thanks again. Thanks for all my new members that came out here. Thanks for joining the team. I got 2 videos coming out tomorrow. So check it, keep a watch out for those. I'm doing one on 2 on the shootings that recently happened. The 2 unarmed black men, and police shot them in the back. So it's gonna be interesting. Oh, Caesar Surgeries was 100% to 0. Damn. Finn's a new member. Thanks, Finn. Thanks for becoming a member. Hope you like what's going on. So again, tomorrow we're going back to our police content. We're gonna go right into it. I've already looked up standard operating procedures. And I think a lot of people are going to be shocked, but, I like to, when I do these police breakdowns, based on my experience as a prosecutor and as a former law enforcement officer, I go into detail and I just give you what the law is, what I'm seeing here, and what the stone cold truth about it is. So hopefully, people won't be too upset at the way I come out, but it just is what it is. You know what I'm saying? The law is what it is. I can't change that. So if anything, I'm going to be seeing you guys later. Thanks again for everybody for watching. I hope you guys enjoyed this. And the next step for this, somebody asked me what the next step was. The next step for this is the judge will decide. The judge is going to tell us what the hell is going to happen, right? So it's either somebody's going to win. And when that happens, we will know. We will know for sure. Tammy T, $5 or $5 Canadian. Steve is sitting... it says Steve is sitting too high on the horse and is about to be bucked off. If he loses, though, I do want to ask you guys this before I leave. If he loses, what does he say? Because he's been going around saying that he's guaranteed to win, right? He's been telling his fans he can't win. His lawyer said he can win. He more or less said the judge said he can win. So if he loses this is going to make him look like such... it's just crazy because... Red's rhetoric. All these people have been making these overarching, betting thousands of dollars, saying that there's no possible way they can lose. I think they haven't, if their lawyer's saying this, I don't even think that may be ethical because you have to manage your client's expectations. You got to tell your client, hey, listen, I'm feeling good about this, but we can still lose this. You know what I'm saying? You got to manage expectations because if he's saying his lawyer's telling him that he can't lose, then, I would be very skeptical of a lawyer saying that. Lawyers should tell you got a good chance, but they wouldn't. I don't know a lawyer to tell you we had 100,000% chance to win. We can't lose at all. That doesn't help the client. That doesn't help anybody. You know what I'm saying? That it just doesn't. So, well, anyway, I'm out of here. Thanks again for watching, and I will see you guys next time. Next filing, our next journey with this case should be the judge saying, I think he's going to say he was improperly served. We got to do it again. Then we get season 2. That starts season 2. If he says yes, then Kyle's got a problem because Kyle's got a contempt hearing, and we'll cover that too. My name is Nate. I'm out of here.